court calls the matter of Futrell versus Futrell, case number 2018-7185 DM. All parties and attorneys will please state their name and appearance for the record, starting with plaintiff's attorney, Ms. Corrigan.
This is Lynn Corrigan, appearing on behalf of the plaintiff, Chris Futrell. My P number is 39840.
Thank you. And I have Mr. Futrell here, and you are Mr. Futrell, is that correct? Harley Futrell?
Yes.
Are you representing yourselves today?
Yes.
Okay, today's date and time set for a motion to show cause hearing. This matter is being conducted by remote technology due to the decisions of the Chief Judge and Supreme Court. The contents of this video may be the official record of a proceeding of the State of Michigan's Ninth Judicial Circuit. Unauthorized duplication, distribution, alteration, or said content is strictly prohibited. Ms. Futrell, you filed a complaint motion to show cause on April 23rd, 2001. Is that correct?
Yes.
You're claiming that you are not receiving your child since October of 2020 in violation of a court order. Is that correct?
It was actually supposed to be November, but yes, it's supposed to be November.
Okay. Ms. Corrigan, how does your client respond to that? Do I set it for a hearing? Where is your client at with that?
Well, thank you, Your Honor. It is true that Mrs. Futrell, Harley Futrell, hasn't seen her daughter since November, but there was an incident that happened in October involving police at Mrs. Futrell's home where she had been run off the road. There was just a lot of chaos and dysfunction, and that event led to the child telling the father what was wrong. Up until then, the 50-50 parenting time had been working, but her grades were slipping and she was crying every Sunday night. So they got down to the bottom of it, had a heart-to-heart, and the child told the father about this boyfriend in the house, this Dustin Gordon, about his relapse into serious substance issues and perhaps some violence and name-calling and fighting, and the child wanted out of there. Mr. Futrell obliged, and then the fighting was such that he did, in fact, blocked her from his phone and had her reach out to the child to make arrangements to visit with her, and he would grant that, but the child didn't want that. So technically, yes, he is in violation of the order. It was in good faith. It wasn't meant to harm the mother-child relationship. And he understands he does have to follow the court's order, that he should have filed an emergency temporary order, but Mrs. Futrell hadn't done anything to complain, and it was cooperative, and he had filed a motion for change of custody, and just Friday, we had a hearing on that regard.
Okay. So I do see in the computer that Mr. Futrell filed a motion for change of custody, parenting time, and support back on December 3rd, 2020, within a few weeks of the alleged incidents. Ms. Futrell, I guess I'm asking you, if you didn't receive your child in November and December, why did it take until, April 23rd for you to file a motion?
Because my ex-husband has never done this before, and he's been civil enough before.
Okay. What type of hearing did you have in front of referee Procunior last week?
Your Honor, I'm sorry.
That was in regards to, we had people testify, and then she spoke to my daughter.
Okay, so you did the custody, parenting time, and support motion last week in front of the referee?
Yeah.
Okay, Mrs. Corrigan, is that a fair assessment?
Yes, it is, Your Honor. The support order wasn't addressed, but that will come.
Okay. Did the referee finish everything, or is it continued?
She did finish. We are waiting for a
ruling. Did she make a
ruling.
ruling on it?
Not on the record.
Okay. if I'm going to do a show cause hearing, I'm gonna have to present all the same testimony you did with the referee. Would that be a fair assessment?
Yes.
Okay. Since you were only asking for civil contempt, Mr. Futrell, if I do find him in contempt, and technically he's in contempt, but as Ms. Corrigan pointed out, there were reasons. And he did file a motion by December 3rd, and there was no objection by you to that until now. So there is some possibility there were reasons for that. Do you have any objection if I let the referee decide whether or not he should be held in civil contempt and there should be any makeup parenting time, Ms. Futrell? Based on the fact she's heard everything already?
Like,
What was that, Ms. Futrell?
I just want to see
What do
my
you want?
daughter.
Okay. But do you have any problem with me letting the referee make that determination?
I don't, but I just hope that I can still be able to see my child, because after the Friday situation, Riley sent me a Facebook message.
Hold on, I don't want you testifying to what the child may have said. Do you have any problem with me letting the referee decide if he should be held in contempt?
Yeah, he should be.
Okay. Do you mind the referee deciding that?
I prefer you to decide that.
Okay. Then is it okay if I at least review the tape?
Yeah.
Okay. Ms. Corrigan, any objection to me reviewing the tape?
I have no objection, Your Honor.
Okay. Then I'll set this for a hearing for 1 hour. 2 hours. I will review the tape of last week's motion for custody and parenting time. I will allow each party to present any other testimony they think is relevant. We're not going to repeat what was already done, but I'll watch the tape, and then I'll allow each party to present their decisions, their sides, or any additional information, and then I will make a decision based on the tape and any new evidence. Is that okay with you, Ms. Futrell?
Yeah.
Is that okay with you, Ms. Corrigan?
Yes, it is, Your Honor.
Okay, then until then, all prior orders remain in effect, and I will review the tape and we'll go off the record and get a date. It'll probably be late, probably in July or August. We gotta wait for a referee to do their order. So that may take up to 21 days. Anything further, Ms. Futrell?
Is there a way that Chris will let me talk to my daughter?
That's not before me today. You can talk to Ms. Corrigan, and if there's something that the parties want to work out through their attorney and yourself, you can, but I can't do that today. Any other questions?
No.
Okay. Ms. Corrigan, any questions?
No questions, Your Honor.
May I make a statement?
You have an attorney. It's probably wise not to make a statement at this time. Your attorney can talk to you and let you know if that's an appropriate statement to make at a future hearing, okay?
Fair enough. Thank you.
All right, best of luck, everyone. We will be adjourned and we will prepare that order, and I'll review the tape and we'll get a date for you. Everyone sit tight. We'll go off the record